Welcome, everyone. It's been a long week, hasn't it? Drinking from a fire hose. What can we do? Thank you, everyone, for joining me today. I hope the Zoom chat is working well, too, I hope. Let me see if I can sort that out. Bear with me 1 second, folks. Sorry, always going to have a little bit of technical difficulties. All right, here we go. Hopefully it's working. Hopefully it's working on Zoom. Hopefully it's working here on Facebook. Welcome, everyone, I'm Eric Meyer. I am a partner in the Labor and Employment Practice Group at Fisher Broyles, and you may know me from a blog I write called theemployerhandbook.com. Thank you, everyone, for joining me today. I really appreciate it. What are we going to talk about? What are we going to do today? Well, we're going to go through the Families First Coronavirus Response Act. We're going to talk a little bit about, we'll get into some of the ins and outs, but I want to keep it pretty broad brushstrokes to give everyone a pretty good summary of what the president actually signed into law. It's going to take effect on April 2nd, 2020 and last until December 31, 2020. But let's see what I can do to help you decipher the Families First Coronavirus Response Act. And then I'm going to go right into some Q&A. And gosh, I asked for questions from readers of the blog, and boy, did you guys send questions. Let's see. I got, when I say questions, I mean questions plural from the same people. Some people sent one or two questions. This is just like right here. This is, I don't know, a fifth of what I've got. So I'm going to try and get through as many of these questions as possible and give you answers. Some people sent me spreadsheets and asked for my comments. I can't really do that. People that sent me, 10, 20 questions, I'm only going to do, I might only answer one or two of your questions. And some other people who sent me some long, integrated, complex fact patterns where I glazed over after the first couple sentences. Sorry, I'm not going to get to those today. But I'll try and delve into as many topics as I can, and I'm also going to work in some of the ADA guidance that we've gotten from the EEOC. I'm going to work in some of the FMLA guidance that we've gotten from the Department of Labor. And I'm also going to work in some of the FLSA guidance that we've gotten from the Department of Labor. So I'm going to mix that in throughout. Like I said in my post today, I intend to go about 45 minutes to an hour. If we go overtime, then we're going overtime. If we end shorter, we end shorter. If people want to bug out, that's totally fine. Early, that's fine. I'm recording this, so don't worry about it. We will post a recording and both of this Facebook video and also hopefully the Zoom chat. I can post a recording of that as well. So, and I'll post that on with links on Monday to the blog. So, without any further ado, let's get started. Let's give you a little summary of the Families First Coronavirus Response Act. So, President Trump signed this. I'm already losing track of time on Wednesday. And like I said, it's going to take effect on April 2nd, 2020, and it's going to sunset on December 31, 2020. And what I'm working off of, I shouldn't show this, maybe I should, I don't know. It is a foreign policy that I've developed. So this is going to be my cheat sheet to give you the ins and outs of the Families First Coronavirus Response Act. So here's some of the things you need to know. There are two parts. We've got the paid sick leave component, and we've got the Emergency Family and Medical Leave Act component. A lot of questions I've gotten, and I'll get into specifics later on. This Does this apply to companies with 500 or more employees? No, it doesn't, unless you are a government entity. So private companies with 500 or more employees, and we'll talk about how you get to 500 or more employees later on, this doesn't apply to you. Also, companies that employ healthcare providers and emergency responders, you don't have to provide those folks with either the paid sick leave or the Emergency Family Medical Leave Act. Additionally, the Department of Labor can exclude small businesses from coverage under either the paid sick leave component or the family medical leave component. That is, exclude small businesses with 50 or fewer employees, with fewer than 50 employees, not 50, but fewer than 50 employees, when requiring them to provide paid sick leave or emergency FMLA would jeopardize the viability of the business as a going concern. How is that going to work in reality? Don't know yet. I suspect that over the next week or so that we are going to, that we'll get some guidance from the DOL as to how those exclusions will work, but we will see. I'm already seeing questions pop up on the Facebook chat. I appreciate them. Thank you for asking those questions. A lot of your questions I will get to later on because they are already covered in some of the email questions that I got already. Like I'm seeing a question right now about the definition of healthcare providers. Where do we get that? I'm getting a message that the Zoom meeting is not working. Let's try it now. I think the Zoom meeting should be working now. Is the Zoom meeting working now? Can someone give me a thumbs up? If anyone's in Zoom, is the Zoom meeting working right now? Hopefully it is. Hopefully no one's sharing their desktop. I think it should be working right now. I think it should be recording. To the folks who are just in on Zoom, again, I'm Eric Meyer. Someone says, love the shirt. Thank you. I love you too. To the folks who are on Zoom, it says we maxed out at 100. Welcome, Eric Meyer, the Employer Handbook, FisherBroyles.com. If you're locked out, it's capped out at 100 people. Hopefully slip on over to Facebook and we'll try it there. Okay, folks, where was I? We're talking about the paid sick leave portion of the Families First Coronavirus Response Act. Here we go. You can take leave for 6 reasons for paid sick leave. Okay, here they are. 1, you are subject to a federal, state, or local quarantine or isolation order related to COVID-19. 2, you have been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. 3, you are experiencing symptoms of COVID-19 and seeking a medical diagnosis. For each of those reasons, if an employee takes paid sick leave, you can get, the employee can get up to 80 hours of paid sick leave at a maximum of $511 per day, $5,110 in total. Okay? Now, there are 3 other reasons you can take paid sick leave. 1, you are caring for an employee who is subject to one of those federal, state, or local quarantine or isolation orders, or they've been advised by a healthcare provider to self-quarantine. If you're taking care of that person, you can get paid sick leave as well. Another reason you can take paid sick leave, you are caring for a son or daughter if the school or place of care of the son or daughter has been closed, or the child care provider of the son or daughter is unavailable due to COVID-19 precautions. So I think I said this during our chat on Tuesday. I am sitting here in Cherry Hill, New Jersey. Our schools are closed. If I weren't doing this right now, if I weren't able to telework, okay, then, and I just had to care for my children all day, I would be eligible to collect paid sick leave. And the last reason is if you are experiencing any other, pardon me with the legalese, substantially similar condition specified by the Secretary of Health and Human Services in consultation with the the Secretary of the Treasury and the Secretary of Labor. If you are taking paid sick leave for any of the reasons that I just said, the last 3 reasons, you're caring for someone else, a loved one, a child, you are taking care of them because they are home from school, school is closed, or you're experiencing any other substantially similar condition, blah, 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 you get paid at 2/3 of your regular rate of pay, up to a maximum of $200 per day and $2,000 in total, okay? Full-time employees get paid up to 80 hours at their regular rate of pay. Part-time employees also get up to 80 hours of paid sick leave. However, the actual number of paid sick leave hours that a company pays is based on the number of hours they actually work on average over a 2-week period. So hopefully that made sense. If not, what I'm going to do as part of Monday's post, because I don't have these slides here, I apologize, is I'm going to post a bunch of really easy to read FAQs that I found. There's one from my partner, Amy Epstein Gluck, which is awesome. I've been emailing back and forth with Jeff Novak a lot. I will share a link to his FAQ. There's one from Sherm that I really like. So if you don't get anything today, if I'm talking too quickly and you miss something, you don't get the notes, listen to the replay, or I'm going to include some FAQs on Monday. All right? Can you ask for reasonable documentation from an employee to support a paid sick leave request? Sure, go for it. You don't have to just take their word on it. But here's the catch. You can never require an employee who is taking paid sick leave to find a replacement worker when they take the leave. Okay, that's not their responsibility. If they want to take the leave, then they can take the leave as long as they're eligible. But the COVID-19 paid sick leave ends with their next scheduled work shift immediately after the time when the need for such paid sick leave time ends. Does that make sense? I'm really quoting that right from the statute. Doesn't make a heck of a lot of sense to me. And the questions I've been getting are, so is it one and done? Do you get like one block of paid sick leave time? And if you break off before the 80 hours are done, do you miss the opportunity to recoup or to get the hours that you haven't used yet? So if you have 80 hours in your bank, you take 40 hours of paid sick leave, and then you come back to work, have you forfeited the other 40? And I think the answer is no. That would be pretty draconian if you do. But hopefully the Secretary of Labor will enlighten us on that when we get some guidance, hopefully over the next week or so. If someone needs to use paid sick leave, what is the call-out procedure? Well, after the first workday or portion of a workday that an employee receives COVID-19 paid sick leave, the employee should be following your call-out rules and procedures. And then with each day that goes on, they should be following your call-out rules and procedures, okay? So make sure you have them. You have them in your handbook. If you don't, start to develop them in connection with a COVID-19 policy that if you haven't developed already, you should be developing, that's going to govern paid sick leave and emergency FMLA. What happens to unused COVID-19 paid sick leave? Well, a couple things. One, if you don't use it, you don't get paid it, all right? That's pretty obvious. Unused COVID-19 paid sick leave does not carry over from 1 year to the next, all right? That's another thing. And don't forget that this Families First Coronavirus Response Act, at least as it relates to paid sick leave and for emergency FMLA, it sunsets on December 31, 2020. And finally, if someone's employment ends, let's say, in May, God forbid, because of financial circumstances, you have to terminate someone's employment and they haven't used their 80 days yet, their 80 hours yet, then they don't get paid out the unused portion of the COVID-19 government-provided paid sick leave. Now, whether they get accrued but unused leave under your other policies and procedures, that's going to vary from state to state. It's also going to vary based on what your handbook says. I'm not going to spend any more time on that right now, but just know that the paid sick leave, the government mandated paid sick leave, does not get paid out if it's unused when someone separates. That's pretty much what you need to know about paid sick leave in the broadest of brushstrokes. And now I'm going to flip into the emergency FMLA and cover that, what's in the act. Again, I'm trying not to quote from the statute as much as possible. Rather, I'm just trying to bring this down into more plain English and give you a basic understanding of what's going on. So, emergency FMLA, available to regular, full and part, I assume regular, full and part-time employees that have been on the company's payroll for 30 calendar days. So for paid sick leave, you start working, you can use it right away. For emergency FMLA, under this new law, you have to have been employed for at least 30 calendar days, all right? The reasons for taking leave, not as complicated and not as thorough and not as many as under the paid sick leave portion. It's really simple for emergency FMLA. You may take emergency FMLA if you are an eligible employee, you've been working there for 30 days, and can't work or telework because you must care for your son or daughter under 18 years of age whose elementary or secondary school or place of care has been closed or the child care provider is unavailable due to a public health emergency. And a public health emergency means an emergency with respect to COVID-19 declared by a federal, state, or local authority. How much leave can you get? You get up to 12 weeks of emergency FMLA leave, okay? Now, and I plan to get into this later on with some of the user questions, but I have this in my form policy that I've developed, so I might as well mention it now. If you are eligible for other forms of FMLA, you can take a total of 12 weeks of FMLA in a 12-month period. So for example, if you've already used 6 weeks of FMLA for your own serious health condition, then you would have 6 weeks of emergency FMLA available under the Families First Coronavirus Response Act. You don't get, unless the Secretary of Labor shocks us with his guidance, you don't get 24 weeks to use. It's 12 weeks total. If you have never taken FMLA leave and you use 3 weeks of emergency FMLA to care for your son or daughter because they're home from school, then you would have 9 weeks left to use for regular FMLA. And this is for employers that have 50 to 499 employees, because employers with 500 or more aren't covered under the emergency FMLA, all right? How much pay do you get, all right? Your first 10 days of emergency FMLA leave are unpaid. However, an employee can substitute accrued paid leave, including, I believe, the COVID-19 paid sick leave if available, all right? And then after the first 10 days of emergency FMLA leave, the company will pay out the remaining emergency FMLA leave that an employee takes at 2/3 of his or her regular rate of pay, up to a maximum of $200 per day and $10,000 total based on the number of hours that the company would otherwise schedule the employee to work. So for a full-time employee, it's full-time hours. For a part-time employee, it's the amount they would have been scheduled to work. The statute doesn't talk about a call-out procedure. I would just naturally assume that you would apply the same call-out rules that you would under the regular FMLA. And frankly, if you want, I think do you really want to insist upon employees calling out every day if they are home taking care of a child that is home because their school is closed? That may be a little bit taxing on HR, so try and be practical about it. Schools that are closed right now, they're not opening up anytime soon. So maybe you might want to relax the call-out policies and have a weekly check-in or a biweekly check-in. So it's something to consider. Job restoration, all right? Once your emergency FMLA ends, the company must restore the employee to the same or equivalent position upon return to work. Now, here is an exception for employers with fewer than 25 employees. If the employee's position no longer exists following emergency family medical leave due to economic conditions or other changes in the operating conditions that a public health emergency causes to the business during the emergency family medical leave, the company must make reasonable efforts to restore the employee to an equivalent position. An equivalent position is one that is similar to the one that the employee held before leave began, i.e. one with equivalent benefits, pay, and other terms or conditions of employment. Oh, someone just asked, and I saw this pop up, did I say that this is being recorded for future availability? Heck yes, I am recording this for future availability. Hopefully the Zoom recording comes out well, but Facebook should be just fine. Getting back to this exception for employers with fewer than 25 employees, if a company's reasonable efforts to find an equivalent position are unsuccessful, then what happens is the employer needs to try to contact the former employee, I suppose, if an equivalent position becomes available within a 1-year period, beginning on the earlier of the date on which their emergency family medical leave ends and the 12 weeks from when the emergency family medical leave began. That was a mouthful. I'm not going to repeat it. In fact, I may end up just sharing my foreign policy with you guys. We'll see. But again, regardless, I am going to post some FAQs on Monday on the blog, which will explain everything I just went over in more granular detail, or at least as much granular detail, but really easy to read, plain English. Okay? All right. Now, let's what a gust of wind. Let's get to those questions. We are at 12:23. I've got at least 30 or 40 minutes of questions. I'll hang in there as long as you hang in there. Let's see if we can get through these things, all right? Let's do it. Oh, there's a question. Can I repeat what the max payout cap would be for emergency paid sick leave? Oh, for paid sick leave, it's 80 hours. Bear with me 1 second. I should have all of this memorized. It's 80 hours for full-timers, $511 per day, $5,110 in total. And for part-timers, for folks that take leave take leave for yourself. If you take leave for someone else, for a daughter or a son, a spouse, it is 2/3 of regular pay, maximum of $200 per day, $2,000 in total. All right, that's for the paid sick leave. And yes, folks, I recognize that I have probably licked my fingers to change pages. Trust me, I've washed my hands as much as I can. I will wash my hands as soon as I am done with this. Please don't shame me too much. It's tough. I'm trying to develop better habits. All right. Now let's get to some of the reader questions that were submitted in advance, and then I'll try, if I can, to get through some of the reader questions that are flying across the screen right now on the Facebook chat. And I'm sorry, I'm not looking right now at the Zoom chat if there are any questions. It looks like Zoom is working, but I can't. There are 47 people in the Zoom room. I can't get to do the chat there as well. Okay, questions. First question. Are office and administrative employees of a healthcare or medical group excluded from the requirements, or are just the frontline providers, such as doctors or nurses, covered? Okay. The act permits an employer of an employee who is a healthcare provider or an emergency responder to elect to exclude those employees from the application of the law. So an employer of an employee who is a healthcare provider or an emergency responder. So I think what that means is that those employees that provide the healthcare or respond to emergencies are the ones that can be excluded. Now, how far does that stretch? Does the person who's at the front desk, who's helping with intake, does that count as a healthcare provider? I don't know. I don't know. I think on the one hand, the goal here is to get coverage for as many people as possible. On the other hand, there's a reason that healthcare providers, there are exclusions for healthcare providers and emergency responders. I would say for sure, doctors and nurses and such can be excluded. Can the person who works IT at the hospital be excluded? That may be a tougher, I think that's a tougher call. The other question that this person asked is, can you give us confirmation that public school districts are required to comply with the Families First Coronavirus Response Act? I can confirm that that is true. Next question. Oh, this is an easy one. Can we require a doctor's note? Yes. Next question. If a person with no symptoms who is not in contact with someone who is affected or under quarantine chooses to self-quarantine just to be safe, they are not eligible. Correct? Correct. Next question. Do partners in a firm count towards, I got a lot of these questions, about the 500 employee threshold. Do partners in a firm count toward the 500 employee threshold? Oh boy. A lot of questions like, how do we count 500 employees? When does the 500 employee snapshot, when is that 500 employee snapshot taken? What if I work for, what if we have a parent and a subsidiary? What if we have affiliated companies? Let me answer this one question about, do partners count? And I think that's going to depend on whether they appear on the payroll. If they appear on the payroll, it's more likely that they count towards the 500 employee threshold. And I think what's also going to matter, and there's a little bit of guesswork here, is the amount of control or authority they wield within the organization. Ultimately, I will say it many times during this chat today, it depends. And hopefully, Eugene Scalia, the Secretary of Labor, will give us more guidance in the next week or so as to how we count towards the 500 employee threshold. All right. Next question. If an employee begins to draw pay under the new provisions and is laid off days or weeks later in a defensible, non-discriminatory, would have been laid off regardless way, is that prohibited? So can you terminate someone who is taking emergency FMLA? Can you terminate someone who is out on paid sick leave? The answer is yes. It's not. Yes, you can. Period. It is not prohibited, period. Although the optics may stink, period. There are anti-retaliation provisions in the paid sick leave. There are anti-discrimination provisions in the paid sick leave. As we know, FMLA has its own interference and retaliation provisions, but the taking of emergency FMLA or regular FMLA, like if I have coronavirus and I work for an employer with more than 50 employees and I otherwise tick the boxes for employee eligibility, I can probably take regular FMLA anyway. If I lose my job during that time period because there's been a reduction in force, it doesn't look good, but that's legal, all right? Has or will the DOL issue any carve-outs for ADA or FMLA confidentiality in the context of a public health emergency like exists under HIPAA? It's sometimes impossible to help coworkers assess the risk of exposure without identifying an affected employee. I've been talking to clients about this, and here's been my non-legal advice, and I probably should have said this at the outset. Darn it. Disclaimer, folks, disclaimer. Disclaimer. Hopefully you're listening to this. Disclaimer, I'm not giving legal advice. I'm not giving specific legal advice, all right? It was literally on my checklist of things to do and I didn't do it. I'm not giving legal advice. Nothing I say here creates an attorney-client relationship, all right? All of these questions you're giving me are hypothetical. So please, let me get back to the HIPAA question. I'm not aware of any relaxing of the ADA or FMLA confidentiality rules that allow you to identify the name of an employee who has contracted COVID-19, okay? You should not be giving the name to coworkers. But what you can say is one of our employees has informed us that he or she has contracted COVID-19 and here's what we're doing about it, okay? Next question. I've only gotten through like 4 pages of questions and I have, I don't know, about 100 of them. I'll see if we can move faster. Oh, someone noticed that my disclaimer was also in my invite. Awesome, thank you. I love doing a belt and suspenders though. If an employee has already used some FMLA time for a typical qualifying reason, does that eat into the emergency FMLA time? Yes, I believe it does. I think I talked about that earlier. You can't stack it. It's 12 weeks total. Is the DOL going to issue new FMLA forms for the emergency FMLA under the Families First Coronavirus Response Act? The regular ones don't really fit the situation. I hope so. In the meantime, many school districts are publishing signed notes online from the superintendent. I know ours has. So an employee providing that pre-signed note from the employer is probably from the school should suffice for now. I mean, if you want to be really rigid and really draconian, you can ask an employee to self-certify that while they're at home, they're unable to telework and they're caring for their child. But I think at the very least, a photocopy of a note from the school that a superintendent has signed for the masses would suffice to at least put you on notice that this person potentially could use leave, assuming they can't telework. Next question. How does the emergency paid sick time and the public health emergency leave, how does the emergency paid sick time and I think the person meant to say the emergency FMLA leave work together? They overlap when an employee cares for a child that is home from school when there's no other child care provider available. That's really the only situation in which both would be triggered at the same time. Next question. This is a question regarding companies with less than 500 employees. I love this question. Will there be any rounding allowed? For example, an employer has 496 employees. Can they round up to 500? Sorry, I'm not aware of any rounding exemptions to the 500 employee threshold rule. But we'll see what the Secretary of Labor says again as to how you calculate 500. But I don't think you're allowed to round up. Sorry about that. Next question. Does the emergency FMLA portion of the bill speak to the use of intermittent FMLA? For example, an employee may stay home with their children 3 days a week, but then trade off with their spouse and be able to work the other 2 days. Would they qualify for emergency FMLA on the days which they are not working? I think this reader of the blog, who I won't identify, but I think this is a great question, might be onto something. May want to go to law school. There was an earlier draft of the House bill which specifically excluded intermittent FMLA and FMLA taken on a reduced leave schedule for folks that are staying home to care for a child because their school is closed. The bill that President Trump signed that is going to become law, that will take effect on April 2nd, says nothing about intermittent FMLA or reduced work schedules. So, can an employee take intermittent FMLA under this emergency FMLA? I think they can. But we'll see what we'll see what Eugene Scalia, the Secretary of Labor, says. But I think they can. I think intermittent FMLA is in play. Hi, Eric. Next question. Hi, Eric. Will the Facebook Live session be available for viewing after it has concluded for those who are unable to watch it live? For those who aren't here today, yes, it's going up. You can watch it later. Do you think we should expect additional legislation covering larger employers? Well, we have a Senate bill that is now pending. To be quite honest, it's like 250 some odd pages, and I haven't had a chance to pour through every word of it. That bill is not going to be like this one, right? I don't think you're going to see another bill that addresses emergency FMLA and paid sick leave, what we're talking about today. I think anything else that comes out of the Senate will provide relief for businesses, tax credits, sending checks to individuals who make less than a certain amount of money. But I don't think you're going to see anything, at least not through the end of the year, that revisits paid sick leave or FMLA. Next question. Is the paid sick leave in addition to PTO that an employer already provides? Or can the employer use already provided PTO to satisfy this new sick pay requirement? I read an attorney's opinion that the wording is unclear. It seems pretty clear to me, but I'm not an attorney. The person who wrote this in is correct. The attorney is wrong. Paid sick leave is in addition to employer-provided PTO. Next questions. Is any employer under 500 exempt from the Extended FMLA Act? We talked about this already. If you employ healthcare providers, if you employ emergency medical service providers, and if you're under 50 employees and abiding by the law is going to jeopardize your business as an ongoing concern, you may be exempted. The healthcare provider and the emergency medical service provider is already built in. I'm not sure how the Secretary of Labor is empowered to exempt others for whom application of this law may jeopardize their business, but I'm not quite sure yet how that's going to work. Hopefully we'll get some guidance in the next week or so. Next question. When is the threshold counted, the 500 employee threshold counted? Is it as of the date of the bill? What happens if the size decreases to less than 500 during or prior to the December 31, 2020 deadline due to layoffs? What happens if the size increases to 500 or more? These are all good questions. Best guess is you'll determine 500 employees at the time the leave is sought. I'm not sure how it's going to get calculated, the 500 employees, but I think it's really when the leave is sought. Just like you would do for FMLA, right? Does someone work at a location that has 50 or more employees within 75 miles, right? I think it's at the time the leave is sought. Oh, that is an employee eligibility issue rather than an employer coverage issue, but we'll see. How does this paid sick leave coordinate with extended FMLA regarding minimum and maximum payments? What would the sequence be should an employee be eligible under both acts? Will you get 80 hours of paid sick leave first, subject to the daily and aggregate maximums? Then the emergency FMLA for the remaining 10 weeks presumably would kick in, subject to its separate caps. That's what makes sense to me. So paid sick leave runs concurrently with the emergency FMLA, and then the emergency FMLA kicks in, assuming, again, it's for taking care of the child who's home from school. But again, let's see what the Secretary of Labor says about that. Let's take a sanity check for folks who are participating on Facebook Live. You liking this? Are we doing all right? You want to hang in there with me for another 20, 30, 40 minutes? Are we good? Everyone hanging in? I see a laughing emoji. I don't know if that's a good thing or a bad thing. All right, I see a few hearts. That's good. All right, let's keep going. So far, no barfing emojis or anything like that. This is all good. I'm pleased. Next question. My question is whether a caregiver receives pay under the emergency FMLA portion of the law, as well as the paid sick leave portion of the law, as well as any company provided paid leave they may have. Okay. Does everything run concurrently? I think the law is a little unclear as to whether we can require employees to take company-provided paid leave with the new COVID law provided leave. It is a little unclear. For caretaker leave for a child home from school, I think, as I said before, paid sick leave, I think what's going to happen is that's going to run concurrently with the FMLA. So the first 10 days are paid under paid sick leave. And then unless the employee substitutes PTO for the first 10 days. And then the remaining 10 days are paid out, the remaining 10 weeks, are paid out at 2/3 pay under the Emergency Family Medical Leave Act. Next question. Basically, is an employee with children under the age of 18 eligible for 80 hours of paid emergency leave because of the school shutdowns? And the answer is no. The answer is no, because you have to be providing care. You have to be providing care for the child. So if you're home teleworking and you're not providing care for the child, then you're not going to get I don't think you're going to get the 80 hours of paid emergency leave. Next question. If an employer has chosen to temporarily close their business in order to abide by social distancing recommendations from the governor and the CDC, and employees cannot perform their duties from home, but none of the employees are experiencing symptoms, caring for others, or told to self-quarantine, are those employees eligible for Emergency Paid Sick Leave Act leave? And I think the answer is no. So, for example, we're going to see that in Pennsylvania. The Governor, Tom Wolf, ordered that all non-essential businesses shut down by 8 o'clock tonight. So can those folks who are at home, who can't telework, can they get emergency paid sick leave? I think the answer is no, unless they otherwise satisfy the criteria, like they're staying home and maybe they themselves are sick with coronavirus, or they're caring for someone who has coronavirus symptoms, or they are caring for a child who is home from school. In that situation, they could get it. But if they're just home with nothing to do because their work has been forced closed or the company has decided to shut down for a couple of weeks, then they're not going to get the emergency paid sick leave, but they can file for unemployment compensation. Is there anything the government can or is planning to do for people like my friend? Oh, the question is, my friend works for I'm sorry, I should have given you the setup. My friend works for a medical manufacturing company that has over 500 employees. My friend, an assembler, lives paycheck to paycheck. Is there anything the government can or is planning to do for people like my friend? So, over 500 employees, no coverage under the laws we're talking about, the divisions of the law we're talking about today. But what the government is doing is seemingly creating easier access to unemployment compensation. And also, under the Senate bill, they're talking about sending out checks, four-figure checks, 1,000, 2,000, something like that. That is what the government, as far as I know, is planning to do. Next question. What we were wondering here in Minnesota, shout out Minnesota, is whether you have to provide an additional, all caps, additional 80 hours of PTO, or can the employer say, use the PTO you have already? It's an easy one. Full-time employees get an additional, or I should say, full-time and part-time employees get an additional 80 hours of paid sick leave to use for covered reasons. Additional. It is additional. You can't just force people to use their bank. Here's another question, and I got some questions from individuals. So I realize most of my audience here, most of the audience here, that's not my audience, it is the audience, are HR professionals. But I did get some reader questions from people who clearly aren't in HR, who are individuals, who are going through a tough time. And I want to share this one. Reader writes, I just signed a severance package for a company I worked for the last 2 years. Am due to start another job. How do the new laws apply to me? The company I'm due to start working for is losing business due to the virus. That means possible delay in start time. Unfortunately, the laws don't cover you yet, even when you start. But when you start, you are immediately paid sick leave eligible. And after 30 days, you are emergency FMLA available. I saw a bunch of questions pop up about even do part-time workers get the 80 hours of paid sick leave? And part-time workers get up to 80 hours of paid sick leave. However, the number of paid sick leave hours is based on the number of hours that the employee works on average over a 2-week period. All right. So I wanted to clarify that. And I see some people are clarifying that in the chat. So thank you. I appreciate that. And folks, I am sure there are going to be times today where I am going to misspeak. I apologize. I will try to I will try to correct my errors, but if I miss one or two, I apologize. That's why you shouldn't don't rely upon this as legal advice. Don't rely upon this as creating any form of attorney-client privilege. These are just hypothetical questions that I'm answering hypothetically. If you have specific questions, call your lawyer, okay? Next question. If an employee requests to work from home for fear of catching the coronavirus and no one in the office is showing signs or symptoms, does the company have to allow this? Answer is no, at least not under any federal law of which I am aware. Now, I don't want to open up a Pandora's box and get into the different state law whistleblower claims that someone may be able to bring because of their reasonable belief that coming to work would create a public health hazard. Okay, but at least under federal law, no, we don't have to allow someone to stay home because of their subjective fear that they may catch coronavirus if they come to work. All right. Oh, this is a good question. What benefits are available to a 1099 self-employed contractor? Great. So if you are self-employed, you can take advantage. I don't mean that nefariously, but what I mean to say is paid sick leave is available to you. Now, do you pay yourself paid sick leave? No. But come tax time when you're doing your 2020 income taxes, whenever those are going to be due, you can get a credit on your income taxes. I don't think it's dollar for dollar anymore. I think it's less than that. It's a partial credit against the paid sick leave that you would have taken. So I hope that makes sense. You can get some income tax relief for paid sick leave if you need it. Here are a bunch of questions that were submitted by the EEOC. Okay, they didn't submit it for purposes of this Facebook Live conversation we're having, but I figured since the EEOC did issue some guidance on the ADA, I should try and weave that in today. So let's talk about some of the important ones. And I don't get to answer their questions, they answer their own questions. So I'm just going to pretty much read off the page if that's okay with you. How much information may an employer request from an employee who calls in sick in order to protect the rest of its workforce during the COVID-19 pandemic? Answer. During a pandemic, ADA covered employers may ask such employees if they're experiencing symptoms of the pandemic virus. And it talks about what some of the symptoms are of COVID-19. Employers must maintain all information about employee illness as a confidential medical record in compliance with the ADA. Good. Oh, by the way, someone just asked, is there a website that we can get this information from, this EEOC information? Yes, it's eeoc.gov. And it's literally right near the top of the page. You just click on it. You're going to see everything that I'm talking about here. And I'm not going to read everything. I'm just highlighting a couple of important questions and answers. When may an ADA-covered employer take the body temperature of employees during the COVID-19 pandemic? Got that question a lot. Generally, measuring an employee's body temperature is a medical examination. However, because the CDC and state and local health authorities have acknowledged the community spread of COVID-19 and issued attendant precautions, employers may measure employees' body temperature. However, employers should be aware that some people with COVID-19 do not have a fever. If an employer is hiring, may it screen applicants for symptoms of COVID-19? Answer is yes, it can do that. An employer may screen job applicants for symptoms of COVID-19 after making a conditional job offer, as long as it does so for all entering employees in the same type of job. So be consistent, that's important. Two more questions from the EEOC that I'm going to give you their answers. May an employer delay the start date of an applicant who has COVID-19 or symptoms associated with it? Yes. May an employer withdraw a job offer when it needs the applicant to start immediately, but the individual has COVID-19 or symptoms of it? The answer is, based on current CDC guidance, this individual cannot safely enter the workplace, and therefore the employer may withdraw the job offer. Oh, someone just said that on the Zoom chat, it looks like you have participants who are not muted. Can you, let's see, can you mute all? Let's see if I can mute all. Let's see if I can, hopefully I can, maybe I can't. Let's see, bear with me 1 second. Oh, I thought I have everyone muted. Sorry about that. I don't know what to do. I thought I had everyone muted. Getting back to some of the questions. I'm done with the EEOC questions, getting back to some of the reader questions. So my question concerns large government entities, such as the United States Postal Service. Hopefully this is just hypothetical, of course. Are we going to get paid sick leave if we have to self-quarantine or get the virus? Yeah, up to 80 hours of paid sick leave. Concerning the new legislation, does this FMLA apply to employees who have already exhausted their FMLA leave for 2020? Is it in addition to existing FMLA leave allowances? All right, here's my best guess. For companies with 1 to 49 employees, this is a new FMLA bucket that never existed before. So you get your 12 weeks, okay? For employers with 50 to 499 employees, it all goes into the same bucket of 12 weeks. So if you've already used 6 weeks for your own serious health condition, you get 6 more potentially under the emergency FMLA. And for companies with 500 or more employees, nothing changes because they're not covered under the emergency FMLA. Next question, how is emergency FMLA calculated for a variable hour employee? Oh, great question. And oh boy, this is going to get a little bit technical. I'm going to read from the statute, and I'll try to substitute in, I'll try to make it as user-friendly as possible. So for a variable hour employee, in the case of an employee who works schedules varying from week to week, this is for emergency FMLA purposes, to such an extent that an employer is unable to determine with certainty the number of hours the employee would have worked if the employee had not taken emergency FMLA, the employer shall use the following in place of such number. All right, subject to what I'm about to tell you, it's a number equal to the average number of hours that the employee was scheduled per day over the 6-month period ending on the date on which the employee takes such leave, including hours for which the employee took leave of any type. Here's what it's subject to. If the employee did not work over such period, so it didn't work for 6 months, it's the reasonable expectation of the employee at the time of hiring of the average number of hours per day that the employee would normally be scheduled to work. Wow, that's a mouthful. I suggest that if you have questions, specific questions about specific variable hour employees, that you call your legal counsel, please. Next question. Would this emergency paid sick be in addition to the federally required paid sick pay that is accrued when working on a federally contracted job? This paid sick leave that the government is providing here now is in addition to any other form of paid sick leave that you have, okay? It's not in lieu of, it's not concurrent with, it is in addition to. Oh, gosh. Heads up, someone on Zoom isn't muted and everyone can hear their phone conversation. Sorry, it's the best I can do. Next. Oh, the U.S. Department of Labor wanted to chime in with some questions for Fair Labor Standards Act purposes. Again, not specifically for purposes of this Facebook Live Zoom chat, but again, trying to be somewhat funny here. I will just read off some of the questions and answers that I think you may want to hear about. Ready? Here we go. From the Department of Labor, and this deals with Fair Labor Standards Act. How many hours is an employer obligated to pay an hourly paid employee? So how many hours must an employer pay an hourly paid employee who works a partial week because the employer's business closed? Answer. The FLSA, we're just talking federal law, forget about state law. I'm not addressing that here. Actually, don't forget about state law, but I'm not addressing state law here. The FLSA generally applies to hours actually worked. It does not require employers who are unable to provide work to non-exempt employees to pay them for hours that they would have otherwise worked. In plain English, if you have an hourly employee who doesn't work, you don't have to pay them wages. Okay, you might give them paid sick leave, but you don't have to give them wages for the hours they don't work. If an employer directs salaried exempt employees to take vacation or leave bank deductions or leave without pay during office closures due to COVID-19, does this impact the employee's does this impact the employee's exempt status? Ultimately, a private employer may direct exempt staff to take vacation or debit their leave bank account in the case of an office closure, whether for a full or partial day, provided the employees receive in payment an amount equal to their guaranteed salary. And here's the general rule. If an exempt employee works any portion of a work week, then you pay them for that work week. All right? All right. Thank you for chiming in, Department of Labor. We're at about 1 o'clock. Again, I'm hanging in there. If you guys want to hang in there, I see we've dropped our numbers a little bit. That's fine. I'm recording this. If you want to bug out, you're free to. I won't be offended. I'm going to hang around and keep answering some questions. Feels like the least I can do for you guys today because you've been so great. Really, like I said in my blog post, on the front lines dealing with so many issues, so many unthinkable issues that we never thought we would have had to deal with. So the least I can do is hang in there with you guys for a little while longer, and let's answer some questions. Question. If we have a short-term disability policy that pays 60% of income after 7 calendar days of illness or temporary disability, does that cover the paid time for emergency FMLA after 14 days? I see you who asked this question. I'm not going to out you. That is a trick question. Person asked, does short-term disability pay 60% for FMLA after 14? The short-term disability pay come into play after emergency FMLA purposes after the first 2 weeks? That's a trick question because you can't take emergency FMLA for your own serious health condition under the Families First Coronavirus Response Act. You can only take it for looking after a school-aged child whose school is closed. So STD is never going to come into play under the emergency FMLA provision. All right? Trick question. How does the Act define employer with 500 employees? I don't think I answered this question. How does it define who an employer with 500 employees is? It is not defined. And the best guess is that we'll get some guidance from the Secretary of Labor. Eric, what about a company that has affiliates on a different payroll? Each affiliate is its own separate company. Is there an aggregate rule where sorry, folks, Siri just kicked in on me. I apologize for that. Is there an aggregate rule or if I added up all the company's employees, we could be over 500, or do I need to treat each company separately? Best guess is that you should apply the joint employer rules that already exist under the FMLA or the DOL's new joint employer rules that apply to Fair Labor Standards Act coverage for purposes of paid sick leave. But I suspect we're going to get guidance from that from the Labor Secretary over the next week or so, okay? Next question. Please confirm that if, someone just asked, did he just say that EFMLA is not for your own serious health condition? Yes, I just said that Emergency Family Medical Leave Act is not for your own serious health condition. Correct, that is regular FMLA, is for your own serious health condition. Please confirm that if employers are providing sick days or FMLA pay starting this week or next, since schools are closed, that it will not qualify for tax credits. We can only take credits or days paid after the bill has passed and 15 days have elapsed. Okay, pause. I'm not a tax lawyer. I'm certainly not giving legal advice, and I'm definitely not giving tax advice here. But in terms of the credits, here's what I've seen. It applies only to wages paid with respect to the period beginning on a date selected by the Secretary of the Treasury or the Secretary's delegate, which is during the 15-day period beginning on the date of the enactment of this act and ending on December 31, 2020. So we're waiting for the Secretary of the Treasury or his delegate to tell us when the period begins for taking credits for paid sick and FMLA. Next question. If an employee has PTO available and has to take off either because they are ill or are self-quarantining, can we make them take the PTO? The answer is no, unless they have already used up their paid sick leave. So if someone's already used up their bank of paid sick leave, they use up their 80 hours, and then they have to take off more time than that, regular FMLA is probably going to kick in, and you can run, under the FMLA, you can run the bank of paid time off concurrently with FMLA. Okay. Next question. Take a company with 1,000 employees nationwide, but spread out over a dozen different locations. Would that company be considered to have more than 500 employees or less than 500 employees under the new FFCRA? They have more than 500 employees if they're spread out. One company spread out in a dozen different locations, aggregating 1,000 employees, they have more than 500. However, folks, if you have 480 employees in the United States and 520 employees in Mongolia, that employer probably would qualify for coverage under the Families First Coronavirus Response Act because, at least under the FMLA purposes, you don't count overseas employees towards employee eligibility or the employer coverage. Gosh, I'm going to skip ahead a little bit. Let's do some Family Medical Leave Act questions that were that were ripped off of the Department of Labor's website. I want to make sure you guys are educated about that. These are available at dol.gov. You might have to hunt around a little bit or just do a Google search for Department of Labor, coronavirus, or COVID-19, Family Medical Leave Act. It'll be one of the first hits. All right. So these are the FMLA questions. Can an employee stay home under FMLA to avoid getting pandemic influenza? No, that is not covered under the FMLA. May an employer require an employee who is out sick with COVID-19 to submit to a medical exam or remain symptom-free for a specified amount of time before returning to work? The answer is yes. However, employers should consider that during a pandemic, healthcare resources may be overwhelmed and it may be difficult for employees to get appointments with doctors or other healthcare providers to verify they are well and no longer contagious. May employers change their paid sick leave policy if a number of employees are out and they cannot afford to pay them all? Federal equal employment opportunity laws do not prohibit employers from changing their paid sick leave policy if it is done in a manner that does not discriminate against employees based on protected class. Be sure to consult state law about that. Be sure to consult local law about that. There was something in one of the earlier versions of the Families First Coronavirus Response Act that would have prohibited employers from changing their own their own PTO policies once the law took effect, and that was actually taken out of the final version. So presumably there's nothing in the new law that would prohibit the employer prospectively going forward from changing its own paid its own paid time off rules, right? But you can't mess with whatever is coming to employees under the paid sick leave law or the emergency FMLA. I think we can wrap this up by 1:30, hopefully. Again, if you want to hang out until 1:30 whenever I finish, great. If you can't, if you've got fires to put out, go put out those fires. I completely understand. I am not offended. Most of you have hung in there. That's awesome. But if you have other things that you have to get to, that's fine. We are recording this. I'm going to post a recording of this when it's done. So if you need to bug out and just fast forward to this point to catch up with where you left off later on, you can do that, okay? I take no offense to people who have to leave. That's fine. Next question. If an employee self-reports that their roommate was exposed to a confirmed case of COVID-19 at work, but their roommate isn't displaying the symptoms, nor has been tested yet, and are we able to tell said employee that they need to self-quarantine at home for 14 days and not come to work? Yes, please do so. Some people may be asymptomatic, so yes, please. If someone reports that they've been exposed to COVID-19, if you can, do keep them at home. Do tell them to self-quarantine for 14 days. Oh, someone just asked on the Facebook chat, where will this be posted? This will be posted on Facebook, facebook.com/the employer handbook. I'll put it there. And I'll also add links in Monday's blog post for sure. I'll put links on LinkedIn. I'll put links on Twitter. I'll put links out the wazoo. There's no way you're gonna miss the replay. All right, unless I screw up recording this, which is entirely possible. Another question from this reader. Also, I know the law won't be effective until 15 days after President Trump signs the bill. Does that mean that if we decide as a company right now to provide sick leave to our workers, this company has no paid sick leave in place at the moment, that we would be obligated to pay the additional 80 hours once the new law took effect? I think there's a pretty good gosh darn chance that you would. So if you want to be extra generous and provide additional PTO now before the law actually takes effect, I think what you've done is just that. You're just being more generous, and you're going to have to pay an additional 80 hours potentially once the new law takes effect. Next question. We are using a rolling 12-month period. So should the employee still be limited to 12 weeks for the year, or would it be different given the emergency situation? I assume this person is talking about FMLA. It is 12 weeks total. Would there be anything in the bill preventing you from laying off employees in the 15-day window now. I guess we're at 13-day window between now and April 2nd. No, there's nothing in the bill that prevents you from laying off employees in the 15-day window. I'm going to assume you're not laying off the employees that are sick. That could be a problem. I assume what you're doing is you're just looking at across-the-board cuts because you're concerned at the cost that providing paid sick leave will have on your business and its liquidity. So if you do an even-handed cut, there's nothing in this bill that would prevent that. Next question, is there any waiting period for the sick leave? No. Answer, no, there is no waiting period. Next question, do the days of sick leave have to be consecutively used by the employee? I talked about this way earlier in the live stream, and the answer, it's unclear, and my best guess is no, they don't have to be consecutive. Paid sick leave. My best guess is yes, if it's emergency FMLA, you can take it intermittently or on a reduced leave schedule. The Act contemplates that the employer would terminate paid sick leave once the employee need is over, but the need for paid sick leave isn't necessarily over because an employee takes it on non-consecutive days, right? So if you're home taking care of a child, right, you might have that support from your spouse or from someone a babysitter on Thursday, but you may need to care for your child on Tuesday and Friday, and then the following Monday. So I don't think it has to be consecutive days. Next question. My question stems from our pilot group who are, literally flying in the air pilots who are home-based out of their state of residence. Their schedules are work 8 days on and then 6 days off. How is this calculated in the 80-hour rule for sick time? I think your pilot group is going to cap out at the daily max, the daily paid sick leave maximum of $511 per day. Again, that, above all, must have been a purely hypothetical question. Please, if you have any specific questions about that one, please call your lawyer and don't rely upon the person who is giving a Facebook live chat, not charging anything for it to people who aren't his clients, okay? Next question. When children's schools are closed, many school districts are setting children up with lessons for set periods of time which the parent then leads. Arguably, telework wouldn't be available at times the parent or employee is quote-unquote teaching, but that won't be the entire day. What's an employer to do? I think that's a really good argument for intermittent FMLA or FMLA on a reduced leave schedule. Other question this person had regarding the expanded FMLA portion of the Act. It says an employee can supplement accrued leave for the first 2 weeks. Any reason why the employee couldn't likewise supplement the remaining 10 weeks to make up the extra 1/3 in wages? And in that situation, I think I liken that to a short-term disability situation where you would not run PTO concurrently. Like if you have an employee who's taking normal old FMLA and they're on short-term disability, you would not run paid sick leave, you would not run their bank of paid time off concurrently when someone's getting paid out at 2/3. So I don't think you would do that here, okay? Are we able to do a reduction in pay? We just implemented a full staff salary increase a month ago. Are we able to roll back the increases? Yes, I think you are. Now, the state of California, I'm not a California lawyer, may have something to say about that, or there's maybe some local law that would infringe upon that. And certainly if anyone has a contract. But if someone is purely at will and you gave them a raise and now you want to roll it back because of these unforeseen circumstances, as long as it's prospective, I think you can do that. I am in the home stretch, folks, almost done. Thanks for hanging in there. We're going to get done by 1:30. What happens when an employee is already on FMLA and now they qualify for the emergency FMLA? Do they now have 2 FMLA claims open? If so, what is the best way to handle this? Okay, they do have 2 claims open, and I would treat it like other forms of FMLA. So get documentation that the child's school is closed and the employee is caring for the child, and both leaves would run concurrently. Hey, Eric, can I get on your list to receive your employer handbook emails? Is this my dad emailing me? No, here's what you can do. You can go to theemployerhandbook.com and sign up there. There's a little space to sign up to receive daily emails with my blog posts from the Employer Handbook. Questions. Oh, this attorney sent me, I think, 10 questions. And rather than just, I was going to throw this in the trash, but some of these questions are quite good, so I do want to give answers. Does the new definition of eligible employee, 30 calendar days or more, apply to other types of FMLA or just public health emergencies? And it just applies to emergency FMLA, okay? Does the new definition of eligible employee require anything more than working for the past 30 calendar days or more? No, that's it. If you've worked for the past 30 calendar days, then you are now eligible to take the emergency FMLA. Under what circumstances can an employer require employees to recertify eligibility under the emergency FMLA? I assume that it's the same as under the regular FMLA. So, someone's medical condition isn't going to change because it's not medical. But I suppose if you have a reason to believe that someone's kid's school is back in session and they're still taking time off claiming emergency FMLA, you're reading the news that here I am in the Cherry Hill School District. If I were taking emergency FMLA and someone read that K through 5, where all my kids go, all 4 of my kids is back open, then someone could ask me, my employer could ask me to recertify. I assume they could. Here's a great question. I really like this one. In households that have 2 parents, do both get the benefit of the paid FMLA, the paid emergency FMLA? We do have some married couples in our organization. Here's what I think. I think both can get the 12 weeks. There are already specific exceptions for spouses that work together in the FMLA regs, but there are specific exceptions in there, and emergency FMLA isn't one of them, right? It's for bonding with a child or for adoption, among other things. But there are specific exceptions, and since emergency FMLA isn't one of the specific exceptions, I think spouses that work for the same company can each get up to 12 weeks of emergency FMLA. But we'll see if the Labor Secretary agrees with me. Question. Who determines whether an employee can telework or work or not? Is it the employer or the employee? I think it's both. The employer will assign the telework, right? So the employer will tell the employee, you work from home. But the employee will then have to determine the work-life balance, right? So I think if the employee says, look, it's impossible for me to telework, I have no one else to care for my children. That's literally what the law is here for. So whether you would otherwise physically work in the workplace or whether you have to work at home, if you're caring for your kids and can't work at the same time, I think that's an employee call. The employee would have to presumably certify to that, but I think that employee would be eligible for the emergency FMLA. Next question. I believe I read that we have to send out a notice to our employees. Will there be a standard one created? Yes, there will be a notice created by the Secretary of Labor for paid sick leave, and I assume there's going to be some other notice created for emergency FMLA. We should get that by, I think it's a week from Wednesday. So a week from this past Wednesday. So by this upcoming Wednesday, we should have a notice to hang in our workplaces. Next question. A question I'm getting a lot here in Delco. Oh, shout out Delaware County. Is whether the new leave and FMLA provisions will apply retroactively to employees already on layoff or termination status from, for example, restaurants and retailers who shut down a week ago. The answer is no. because they're no longer employed. If you're on layoff, you're no longer employed. If you're on furlough, you're no longer employed. If you are on, if your employment has been separated permanently, you're no longer employed. Now, this person was writing to me from Delaware County, Pennsylvania. Pennsylvania is pretty employer friendly. Might the rules be a little bit different with respect to furloughs and layoffs in some utopia, or employee utopia, I should say, well, at least before all of this went down, like California? I guess. So layoff may have a different definition over there, but I think if you're no longer employed, what you should do is tell your employees to go file for unemployment compensation. That may be their best bet for them to get paid some money. In fact, if you're paying someone some paid sick leave or emergency FMLA while they're on layoff status, that could, I don't want to say jeopardize, but that might be an offset against what employees would otherwise get through unemployment compensation. Please address how this law affects small businesses and what exceptions or exemptions really means. And the best I can tell you is that the Labor Secretary can exempt small business if the new rules would force them out of business. So I suspect we'll get some more guidance as to how that will work over the next week. I've been hypothesizing, and I don't really want to share it here because it's just what's been rattling around in my head as to how this could work. But hopefully we'll get some guidance in the next week or so. Next question. How do you define unable to telework? How would I define it? Because it's not in the statute. I would define it as either the work is not suitable to telework, like, if I'm a landscaper, I can't telework, or my parental duties don't allow me to take care of my child who is home from school and work at the same time. So if I have to choose one, namely taking care of my child, over the other, working, then I am unable to telework. That is Eric Meyer's definition. Please don't cite that in any of your legal briefs. Or maybe do cite it. I don't care, but it's not going. No judge is going to take it too seriously. We have a total of 87 employees, but do not have 50 or more at one location, and we don't fall into the 75-mile radius. Are we being thrown into the FMLA piece of this through the new bill? Yes, you are being thrown into the FMLA piece through the new bill. Next question. Our company is a staffing company with 250 to 300 temps. Ooh, we're going to talk about temporary staffing. Fun. On the payroll. Most of them are employed in manufacturing plants. If one of our temps gets sick with COVID-19, are we, as the staffing company, 100% responsible for all sick time payments, or is this burden shared through the joint employer law? That is a great question. If you were to put a proverbial gun to my head, I'd say you're responsible because you're probably otherwise paying their wages and benefits and getting reimbursed by the manufacturing plant. But I suspect that this is an area, especially where we're going to get some guidance, hopefully, but I suspect that we'll get some guidance from the Labor Secretary as to how that would work, okay? Because literally, this is the first time that we've had some kind of federal leave law that is requiring payments. So hopefully the Labor Secretary recognizes that staffing companies are going to be affected by this a lot and will give some guidance. Oh, I am down to my final six sheets of paper, and then I'm wrapping up. Can we offer financial incentives to essential personnel to encourage them not to use the 12 weeks of child care? Oh, can we offer financial incentives to essential personnel to encourage them not to use the 12 weeks of child care for FMLA? My fear is that we will have too many employees on paid leave and not be able to provide essential functions. I'd say that you can. I'd say that you can offer it, but don't insist that they take it. So if you do that, do that cost benefit analysis, you can pay people more to remain at work so that they can go out and find help to care for their children, right? If the calculus works in your favor and it works in the employee's favor and everyone signs off on it, I'm okay with that. But don't force anyone to forego paid sick or emergency FMLA, or regular FMLA for that matter. Next question. Let's talk about commission-only salespeople! 50% of my workforce are outside loan officers who don't get PTO or an hourly rate. Would I calculate using minimum wage? It's based on the regular rate of pay. So, and regular rate of pay under the Fair Labor Standards Act includes commissions. So that's how you would calculate it. Next question. Just for clarification, are there still the 3 reasons for the emergency FMLA? No, there's just one reason, and that is for taking care of a son or daughter whose elementary or secondary school or place of care has been closed, or the child care provider is unavailable due to a public health emergency. This does not apply to children 18 and over, correct? I assume we're talking about the FMLA provision, the emergency FMLA? Correct. Emergency FMLA only covers care for children who are under 18 years of age. If they're old enough to vote, then you do not get emergency FMLA. Can the extended FMLA be used for employees whose hours are being reduced? Answer is yes. Yeah, you can certainly use it there. Last question. If a person is away from work due to coronavirus, is that person first covered by the 2 weeks of paid sick leave and then by the expanded FMLA? Like I said before, I'm guessing, and hopefully we get clarification next week or in 2 weeks, that for the first 2 weeks, paid sick leave and emergency FMLA will run concurrently. And then for the final 10 weeks, it's going to be just FMLA. That was my final question. Folks, it is 3 minutes shy of 1:30. I want to thank you all, the 189 folks who are left here, now 190. We started with about 500 on Facebook Live. I know we had some technical difficulties on Zoom. I apologize for that. Hopefully some people were able to take part in that. I'm going to post whatever recordings I get as soon as I finish recording, whatever that means. I'm getting a little punchy here. What else can I say? Thank you. I'm Eric Meyer. Again, I'm an employment lawyer at Fisher Broyles. So, check us out, fisherbroyles.com. That's FISHERBROYLES. Or don't. If you have questions, call your own lawyer. But please come over to my blog, theemployerhandbook.com. If you're not a subscriber, you can become a subscriber. It's free. Tell your friends. They can become subscribers. I actually pay for it. That's fine. I have no problem with it. I love having the subscribers. I love having the readers. So please do come on out. And you guys, like I said in the blog post this morning, I see all these thank yous. You're welcome. You're welcome. You're welcome. It's my pleasure. I will continue to help you guys out. If there's any other, breaking news or big bills or anything like that, maybe we can do another chat again. Otherwise, I'll keep you updated on the daily. And, stay strong, stay compassionate, stay healthy, and have a great weekend. All right, folks? See you on Monday. Bye.